therefore I think it's particularly fitting that we're doing international issues and contracting. I'll introduce each panel member as they begin. I'm James A.T.M. Viator, a perfect moderator for international issues and contracting since I'm from the foreign country of Louisiana. The only state in the Union to have the French and Spanish civil law in codified form. So I hope maybe there will be some recognition in some of the presentations today for the civil law and Roman law content in the Western legal tradition. Our first speaker today is Assistant Instructor Reza Beheshti of the University of Leicester, where he is also a PhD candidate. And his presentation today will build on and reflect some of his research on the comparative and normative analysis of termination, particularly focusing on the Unidroit, the UK Sales Act of 1979, the CISG, and comparative ways in which termination is handled, which is an odd term because it's neither a civil law term nor a common law term. So we'll all have to translate in our own minds during this presentation exactly what that means and what the ideas behind it for contracting parties. And so Reza will begin first. I'd like you to welcome him especially warmly, not just because he comes from England where it's freezing today, but because it's also his birthday. So this is a very warm welcome.
Okay. I'm very delighted to be here, and first of all, I would like to thank Jennifer for putting all these together. She has done an amazing job, and also St. Thomas Law Review for funding me to come here and enabling me to fly over to the US. So this is a bit a special day for me because it will be my birthday, so probably I will be a bit nervous, but anyway, I'll try my best. So this is part of my research project that I'm doing in Leicester now, and I will, in that project, I am focusing on buyer's remedies from comparative analysis point of view, but not just doctrinal analysis, comparative point of view, but also normative analysis. So this is part of that, and so I will scratch it a bit. So when I mean international sales transaction, I will focus on the four dominant, as I can say now, international legal regimes dealing with international sales. The very first one is English Sale of Goods Act, SGA, 1979. The second one, CISG, United Nations Convention on Contracts for International Sale of Goods, 1980. The CESL, the proposal for a common European sales law. This one is still a proposal. It has not been ratified yet, but there is a very vast and rich literature on it. So it's still under legislative process. And the last one is UPIC, which is Untitled Principles of International Commercial Contracts. So I will start off with the exact definition of termination. In my point of view, it's relatively an accurate definition which has been proposed by German scholar Treitel. A party, so what's termination? A party who is aggrieved as a result of not obtaining the performance for which he bargained may wish, in a general sense, to put an end to further performance of the contract, and also as far as possible to put matters back into the position in which they were before performance on either was begun. So this is the definition. But as Professor James mentioned, there are lots of terminological inconsistencies in this area, especially for the word termination. For example, if you look at Sale of Goods Act, they haven't used termination. It has used rescission. But as we are aware, rescission relates to vitiating factors like mistake, fraud, and it avoids the contract ab initio, as if the contract was never existed. Or under CISG, it's funny, it has used just avoidance. And they haven't used termination. But I think more easier and clearer definition is what it has been focused on CECL and UPIC. They have used termination. And I think under the UCC Article 2, they have used dissolution, which is, that's why inconsistencies exist. So what I'm going to do is, firstly, I will tell you what are the similarities between these legal regimes. If you look at the regulations governing termination of contract, the main similarity is that the main ground for termination of contract is substantial deprivation of what was the buyer was entitled to get. So this is the main factor. Although there are still inconsistencies, for example, under English sales law, there are inconsistencies saying that substantial deprivation or substantial non-performance, but still they are focusing on substantial breach or fundamental breach of contract. Although England was totally different because we had the traditional dichotomy of classification of terms into condition and warranty, but the introduction of innominate terms does resemble many, does bear lots of resemblance to the fundamental breach of contract. But one thing that, so this is a bit of a growing project, so this is not finalized, but one thing that I pointed out, probably there might be some differences in foreseeability or remoteness test under English sales law and the fundamental breach under other legal regimes. Because if you look at the definition of fundamental breach of contract, it has been mentioned that the party who is in breach should have foreseen that the other party will be deprived of the substantial deprivation. Under the innominate terms definition, such foreseeability requirement is absent. Probably we can imply, because they will focus on the intention of the party in breach, but it has not been expressly mentioned anyway. So, but this is not what I am focusing on this presentation. But, and also the prospective effect of termination operate almost the same under these legal regimes. Both parties will be relieved from their future obligations, and there won't be any future, but some clauses might be operative still, like arbitration clauses. And also it might be interesting from legal history point of view that there are some discussions saying that the origin of fundamental breach of contract is emerged from English law from 1950s. But I haven't seen any kind of article dealing with that very properly. But Will, in Bianca and Bonnell book commentary on the CISG, has mentioned that fundamental breach refers to a Danish expert in preparatory work, ULIS, which has been carried out in 1951. So still there are inconsistencies here. So I will focus on this significant difference between restitution, which relates to the restitutionary interest under these legal regimes. This restitutionary effect relates to the risk allocation. So if you look at CISG and Sale of Goods Act, it mentions that the buyer's right to terminate is excluded whenever the person who wants to terminate the contract is supposed to carry the risk. This means that if the buyer is unable to restitute in kind, his right is generally excluded. Whereas if you look at under the CECL and the UPIC, if restitution in kind is not possible, the monetary value of performance should be rendered. And this might render the termination of contract extremely hard. And I will tell you why. But before dealing with these different regulations on restitution of contract, I'd like to tell you something about restitution. generally, there are not vast amount of literature about termination in international sales. Whereas if you look at damages or specific performance, there are huge amount of literature. As Michael Bridge, one of the biggest head of international sales in England, he said that the restitution provisions are difficult to measure and understand and are sparse in detail. And they have attracted, and then they said that they have attracted little attention in the case law and literature. But the point is that it would be really hard, because this is my focus will be on international commercial buyers, not consumers, even not internal commercial buyers, international commercial buyers. It's very common for a commercial buyer not to be able to restitute in kind, especially when he might have already sold it to his sub-buyer, or he might have used it in his factory so that it has been transformed, or it has been changed substantially, and that the goods is not really available. So what should we do then? Okay, so I will give you a brief overview of what is the position under these legal regimes. Under English sales law is that the parties must restore the performance. Although under the Sale of Goods Act, there is no real express regulation about that. It is in case law. But the exception is that if the buyer is unable to restore them due to the very defect which has been given rise to the right to reject, he will still be still entitled to terminate the contract, although restitution in kind is not possible. And also, where the restoration of the goods is made impossible by some external cause, by some accidental cause, he might be still entitled to terminate the contract. And these are two relevant cases, very leading cases, Rowland versus DeWall, and also Head versus Tattersall. The position under the CIC, interestingly, is quite similar. The CIC excludes the right to terminate the contract if restitution in kind is impossible. Article 82. But there are three good exceptions to this general rule, which has narrowed down this general principle, which is more pro-buyer. It's more buyer-friendly rather than seller-friendly. So the very first one is that if the impossibility of making restitution of the goods or of making of restitution of the goods substantially in the condition in which the buyer received them is not due to his act or omission, or it has been deteriorated or perished as a result of the examination of goods, because the buyer is under huge kind of obligation under the CISG to examine the goods and to notify the defect, Article 38, 39. And also if the goods or part of the goods have been sold in the normal course of business or have been consumed or transformed by the buyer in the course of normal use before he discovered or ought to have discovered the lack of conformity. This is very good exception, which is specifically suitable for a commercial buyer. The position under the UPIC is that either party may claim restitution of whatever it has supplied. If restitution in kind is not possible or appropriate, an allowance has to be made in money whenever reasonable. And the exception is that if such destruction relates to the seller's fault, the buyer is exempt from paying the monetary value and terminate the contract. So what does it mean? This means that the buyer has to compensate the seller for even accidental loss. So there is kind of correspondence between the risk and the control. So whoever has the control or influence over the goods, he should carry the risk of any kind of loss under the UPIC. But the only exception is that if it just relates to the seller, the buyer is exempt from kind of paying that monetary value. But this is funny under the CECL. Under the CECL, Article 172, it mentions that when a contract is avoided or terminated by either party, each party is obliged to return what that party has received from the other party. So this is the main rule, which is similar. But the exception is that when what was received, including fruits, were relevant, cannot be returned. Or in any case of digital content, whether or not blah, blah, the receipt must pay its monetary value. So cannot be returned includes three kind of situations. So it cannot be returned either because of accidental loss, it cannot be returned either because of buyer's fault, or it cannot be returned either because of seller's fault. Under these three situations, the buyer is still under duty to pay monetary value in order to terminate the contract. And this is funny because the Soel drafters, they mentioned that we are going to protect the SMEs. They're meant to be buyer friendly, but this kind of regulation might not make sense in terms of my comparison. Okay, so this was a brief comparative overview. But what I'm going to do now is to introduce my nature of the framework, my normative framework that I will be focusing on. So this framework is particularly designed in light of the commercial realities and needs of international sales, and can be applied to the full range of buyer's remedies made available by the main governing legal regimes. The very first one is certainty. So buyer needs to know where he will stand after the formation and conclusion of the contract. And certainty does not involve only the clarity of words, but also he should understand where exactly he will stand because of the consistencies of the regulations. So a rule, for example, granting discretion to a court or arbitrator or employing general concepts such as reasonableness will provide less certainty than a more prescriptive remedial rule. So under certainty, the CIH's approach is the most certain one. First, as a general point of view, is that ascertaining the monetary value allowance renders any approach vague and obscure. So monetary value should be assessed and ascertained by referring to the market, and market definition is really vague, and nobody knows what will going on when the termination is going to happen. And I submit that the CIH approach is the most certain one with regards to a commercial buyer due to the exceptions provided under CIH Article 82, because he can specifically predict that if he pursues his normal commercial activities, he will be able to terminate the contract and return the money paid. And the main problem with Sale of Goods Act is, under English law, if you are going to terminate the contract and restitute the goods, you need to prove total failure of consideration. And this renders restitutionary system of English sales law vague and obscure. Such requirement is absent under other legal regimes. The UPIC is the most uncertain one due to the use of the vague terms of appropriateness and reasonableness, and also the Soel is uncertain due to the employment of vague terms of unreasonable afford or expense. The second one, which is my second criterion, which is more interesting, is performance interest. So a buyer enters into a contract in order to get what he expected to reach after the conclusion of the contract, because he places a higher value on the other party's performance. And it's important that it is the only pure contractual interest, to mention that. And this performance interest has been introduced by Daniel Friedman in his phenomenal article. My submission is that the CIC and Sale of Goods Act approach respect the buyer's commercial activity. So this is a bit vague. So the general point is that none of these popular approaches under termination of contract satisfies the buyer's performance interest. So termination actually blocks the buyer's commercial activities. It doesn't really satisfy what the buyer wanted to reach after the conclusion of the contract. But the main point is that the CIC and Sale of Goods Act, it does not infringe the buyer's performance interest. It does not satisfy, but also it does not infringe the buyer's performance interest. In other words, it respects the buyer's performance interest. And why? Because under the CIC, if the buyer does his normal commercial activities, he doesn't need to return back anything to the seller. And if the goods has been unavailable, these regulations protects him, and he doesn't need to disgorge himself from the profits that has acquired. That's why I say it respects. It doesn't satisfy, but it respects. But the UPIC and the CECL impair the buyer's performance interest by obliging the buyer to pay the monetary value and disgorge him the benefits he has acquired from his commercial activities, and more especially the CECL. And the very last one is efficiency, in the sense that transaction costs are reduced. So, in terms of efficiency, I would focus just on transaction costs, because efficiency is really wide. We have Kaldor-Hicks efficiency, Pareto optimal efficiency, but I would look at just efficiency in the sense that transaction costs would be minimized. And this is important because in an international trade context, we can assume that the parties' goal is to maximize and increase their profits by entering commercial transactions. And the criterion of efficiency can guide the commercial actors to choose the legal rules that maximize their benefits. And according to my efficiency point of view, CISG is the most efficient one. And why exactly? Because first of all, it hasn't used those vague concepts so that litigation costs would be minimized. There won't be any harm on the courts to understand what reasonableness referred to. It doesn't harm the court what appropriateness refers to. And also, it would reduce research costs for the parties, because under the UPIC and the CECL, the parties, especially the buyer, needs to understand what is the market value of the goods, so he needs to go and research, and it might have some costs. And the least efficient one is the UPIC, because of the employment of, again, those vague concepts of appropriateness and reasonableness. And also, sale of goods like is equally inefficient because of the requirement of total failure of consideration. And this is my conclusion, that CISG is generally the best legal regime on termination if we are looking at the differences. So this is my conclusion, and this was my presentation.
Thank you. My next speaker is DiMatteo from the University of Florida College of Law, and continue on with my somewhat strained Louisiana connection to international law and all the topics here on this panel. Larry's going to compare the sales law of the UK and the United States, and as most UCC Article 2 professors know, Carl Llewellyn was greatly influenced by the German Civil Code when he drafted UCC Article 2. And a less well-known fact is that Judah P. Benjamin of Louisiana published the most famous treatise on sales in England in the late 19th century, to where he fled after evading Union capture at the end of the Civil War. And his Benjamin on Sales was sort of a Bible in England for decades and decades, and it was heavily influenced by the Roman law of sale. And so maybe there's more similarities than not, but Larry's going to let us know.
All right. Let me just get this thing where, why can't I find the right one? All the way from the beginning. From the beginning there was. It's great to be here today. I have so many great friends in the audience, Dan and Frank and Charles and Lex and Reza. I actually met in Scotland not too long ago. I was Bader from the University of Leicester, where I spent 3 months a few years back. So I have a fond memory of that place. This is a project that's in its infancy, and okay, all right. So it's part of a larger project on comparative law that I'm happy to say just went to the board at Oxford Press yesterday. So we're real hopeful that this will work, and Dan is a co-author of mine, and I have a co-author for this piece, which is a comparative analysis of the American sales law and the English or British sales law. So anybody knows me, this presentation is high on style and little of substance. It has a long way to go. I do have an English counterpart that's going to bring, hopefully, the analysis on the sale of goods because, as was previously stated, I think the CGA, Sale of Goods Act of 1979, is very vague and opaque, and it just doesn't give you a lot to go by, and I think the case law reflects this. The point that I'm going to point out more than anything is probably not very novel, but the tremendous impact that our sales law, Article 2, and along with it Article 1, has had on the common law in the United States. Well, you don't see any of that kind of impact that the SGA has had on the common law. The difference being that the England is part of or Britain is part of the European Union clearly has that type of influence that has impacted their common law. That's the only really external impact that I can see that has really moved begrudgingly on unfair contract terms and things like that, the English law, which, as we know, the English think is a perfect system that needs no adjustment whatsoever. But part of it we can see just in the goals and purposes in the initial preamble or articles of the two laws. The UCC seeks to harmonize sales law. Well, that's the given, that we have 53 common law systems in our country, and there was a real need to clear up the chaos among the different states with our harmonized law. And this is, of course, the United States' greatest codification of private law, but it is still important to realize that it is embedded in the common law system, and therefore is really what the judges say more than what the code says. But the key here is to simplify, clarify, and modernize commercial law, the key word being modernize. Llewellyn, thought, rightly so, that most of commercial law was obsolete and needed complete revision and modernization. And as part of that, a sort of process of an expansion of the commercial practices going forward to filter back into the UCC through the so-called incorporation strategy. Well, we compare that to the English Sale of Goods Act, which is what it's really called, but when I was in Scotland, they kept on telling me I had to call it the United Kingdom Sale of Goods Act because of the Scottish influence. But right from its get-go, it had a very modest sort of a goal, simply to consolidate the common law and restate the common law. There's no hint of being progressive, introducing innovative terms and stuff to create a more modern contract law. And we see that in Article 2, where it really is a fine print contract all by itself. It deals with most issues of contract law, provides the gap fillers or default provisions, and provides official comments that help us along. The ESGA is very sparsely worded. There's no commentary or official commentary. And quite frankly, after reading the BGB for the first time, I was very disappointed in reading the SGA because it is an international sales law. It very much was the international sales law. Now we have the CISG, but still the English sales law probably is more dominant or predominant in international transactions than the CISG. And so I was very disappointed by how little it gave me in the way of knowledge and guidance. So when we really look at American common law of contracts versus England, we see English law is very much still trying to cling to the old classical contract law, which means a certain degree of formalism and things, a rejection of the duty of good faith, not a lot of fudge factor or flexibility, and clearly the UCC moved American common law along that track much faster than we see in England, which is now really coming along. It's really, it created the divergences that we see, I think, in common law contracts in England versus the United States, simply because we had the UCC and its influence and its application by analogy to the common law of contracts. Okay. So the reasonableness standard, which of course also is somewhat in place in this English law, but not in its dominant form as we see in the UCC Article 1 and 2. It is pervasive there. It's saying, okay, the law is found outside of these rules. These rules will be constantly refreshed. And even though the revision of Article 2 failed, it's the only article that has not been revised in our law, it still seems to do the job pretty well. And I think it's because of these open textured rules and the reasonableness and these sort of flexibility that the duty of good faith, which we see, has had a tremendous effect on the common law of contracts in the United States. So we now see an employment law, an implied duty of good faith in some states that would allow some sort of cause of action in the discharge situation, which under our employment at will doctrine wasn't there. Unconscionability and impracticability. My view of these things is unconscionability has had relatively little influence on the common law, other than it's there. But at least under the Article 2 mode, it's supposed to apply to merchant transaction as well as the consumer transaction. And even though I didn't see Charles's presentation, you know, most of the unconscionability cases involve consumer contracts. Very few merchant-to-merchant transactions. And there's no reason for that, because we see, as Dan would I'm sure agree, that the same bargaining disparities in merchant contracts as we see in the consumer contract. Yet American courts have been very, very slow in saving a business concern from an unconscionable contract. Impracticability, I just started working in this area, and I was just stunned in looking at the 200 cases that I randomly selected, how almost impossible it is to win a claim of impracticability. And you know, this was supposedly was going to liberalize our excuse law, and we think it has because of the sound of the term, but it's really very rarely utilized in our actual court cases. How much time do I have?
You have 8 more minutes.
8 more minutes, good. I want to get to, so when we see UCC contract law, we see, as compared to the common law in England, and even as stated or not stated, I guess you should say not stated in the SGA, a real liberalization of classical contract law with the removal of the definiteness of terms requirement. Just as long as there is a general intent to enter into a contract, the courts will, at least in sale of goods contracts, do the job. No new consideration is needed in the modification of contracts. We have the firm offer rule, a really horrible battle of the forms rule. But we have that. The written confirmation, which is so large in the civil law, dominant in German law, the concept of a written confirmation. Once again, I guess you referred to the Llewellyn influence, and that being the German law of which he studied very much, had a strong written confirmation rule, and then the unilateral contract. The duty of good faith is just, as I say, an example of how these principles of the UCC bled out into the common law system and are used in all contracts now, this general duty of good faith. Now even we see in business organizations, the limited liability company, in which the Delaware statute in 2006 allows the operating agreement, which is the foundational document for limited liability companies, which is now the dominant form of business organization in the United States, to exclude all fiduciary duties. the duty of loyalty, the duty of care. But since it's based on freedom of the contract, it cannot exclude the duty of good faith and fair dealing. So you can see that this will play even more important of a role, because no one knows what the duty of good faith means when it comes to governance of organizations. So we can't exclude it, but then again, it's an empty vessel that needs to be filled. And hopefully it'll be filled with things like fiduciary duties, which are supposedly excludable under the Delaware statute. So tremendous potential effect of good faith going forward. The UK rejection of the general duty of good faith until very recently, 2013, late in 2013, the Yam Singh decision in which Justice Laggard recognized the duty of good faith, but only as an implied in fact doctrine, still rejecting good faith as a general implied duty. So clearly the courts are supposed to look at the facts of the case, the trade usages, the expectations of reasonableness between the parties, and can imply in fact that the parties agreed to a duty of good faith, but still a rejection of an overall general duty of good faith, which has been embraced under American law, once again because of the influence of the UCC. Contextual interpretation, I just want to skip ahead. So in the UCC, we have an ordering of evidence that can come in. Really, Llewellyn's embrace of contextual evidence, of which he would hope to, I think everybody views it as an ordering, which it is stated as such, that the express agreement is stronger evidence than course of performance, which is stronger than prior dealings, which is stronger than custom and usage. But I've argued that Llewellyn really wanted it all to come in, that it was not a sort of hierarchical contextualism, it was a flat contextualism. But he lost, the fight in committee. And so he didn't get some of the things he wanted, like the merchant rules and the merchant tribunals. And I would argue that his view of contextualism is very similar to what I would call full contextualism, which is the CISG approach, that everything comes in, even if you have a fully integrated written agreement. The English, once again, we can argue whether formalism still plays a role and the parole evidence rule is hard or soft, but clearly the American courts embraced the use of contextual evidence in deciding the meaning of the words of a contract much earlier than the English, and they're still grappling with it in a major way. But the watershed decision was the investors' compensation scheme, which is sort of like the Marbury versus Madison version for contract law. It is the most cited English law case of all time. And it harkens back to Reardon Smith, where Lord Wilberforce talked about the need to construct a matrix of facts in order to interpret the written words of a contract. We call that the totality of the circumstances. But it was Hoffman that really brought it home in 1997, the old intellectual baggage of legal interpretation, which is what we would call legal formalism, the idea that we take a plain meaning interpretation of the words of a contract. Admissibility, at one point he says absolutely anything should be admissible if it gives us a reasonable person interpretation of the meaning of the contract. However, there are linguistic mistakes, very few, he would argue, and this really doesn't necessarily equate to ambiguity. It's the idea that the parties actually just chose the wrong words, or that if we interpret it based on these words, it ends up with a ridiculous outcome, and therefore the parties couldn't have intended this. There is an exception, negotiation relative to the subjective intent, which is really the basis for our parole evidence rule, to allow people to take the stand and say anything they want. But that plain meaning isn't the meaning of necessarily of it, and not the same thing as the meaning of the words. The words themselves, the meaning that we construct from that, at least without using context, is clearly not the meaning that we care about in the contract. We care about what the parties thought those words meant, and therefore contextualism is the way we have to, what they call the background. And Lord Wilberforce, in his decision, opened up the idea by this matrix of facts that we have to look at the background behind. All this seems so simple to us American scholars because we've been talking about this for many decades. But Hoffman's opened it up and defined background as absolutely anything. And when I was in Scotland at the conference, the Society of Legal Scholars Conference, we had a conference before that, and we had just a wonderful presentation by the Right Honorable Justice Hodge, who just ascended to the UK Supreme Court just a few months ago. And he gave a presentation on contextualism, and it will be probably the opening chapter of our book. That was just wonderful. I wish I could get a written version of it, but he promised, because it was written, he even had footnotes, but he wouldn't actually give it out to us at that point. But he went really through, you know, the Wilberforce and the Hoffman cases and gave just an impassioned talk about how English common law has to go even further in the contextual interpretation of contracts. I would think he would be a gentleman that in the future would, or possibly, recognize an implied duty of good faith. Well, I got 1 minute. So my only substantive material was on warranty law in the English common law. So let me just go real quickly if I can. The Sale of Goods Act of 1893, the implied warranty of merchantability, which is section 14.2 and was carried over to the present Sale of Goods Act of 1979. Clearly a right to disclaim, both expressly or by trade usage. So the disclaimer can be simply that in the trades, we don't imply a warranty of merchantable quality, and it would be excluded. Exclusion by inspection. So if a consumer, for example, had access to the goods, walks into a store, and inspects the good, then theoretically they're excluding all implied warranties, that being the merchantable quality, even as to hidden effects, defects. You disagree with that, Frown, or do you think that's stupid? Yeah, of course. Thank you. So the definitional problem, of course, is like with anything, what does merchantable mean? And there are different thresholds of functionality, and basically they look to saleability, not to usability. That is, if it's saleable, then there is no protections. If it is then, after it's sold, is found to be defective, that it isn't usable, you don't have any implied warranties here. They're disclaimed. They're excluded. But of course, this is 1893. In the Implied Terms Act, which I think is 1973, there's a bifurcation of warranty law, which we don't have. So they distinguish consumer contracts from merchant contracts and make the implied warranty of merchantability, or what we call merchantability, an immutable principle. They cannot disclaim that implied warranty. Inspection by consumer only disclaims the patent defects, not the latent defects. And then in 1994, they shift to a term called satisfactory quality. So instead of merchantable, it's satisfactory. And this is still evolving. They do provide some sort of factors analysis. These are the items listed as things that could be considered by the court in implying a remedy. But then we have this 2004 case, quality determined independent of the actual buyer's perspective. So this is a construction of the reasonable person based on nothing to do with the actual buyer. Okay, it is the reasonable person looking at the goods and saying would, a reasonable person find these goods to be of less than satisfactory quality. The actual person, the actual buyer in the case is irrelevant to this determination. So they're still trying to work out this, construction of the reasonable person is a matrix of facts, and here it is applied in the warranty setting. It is causing some confusion and is still evolving. And that is the essence of the paper. Thank you.
Our final speaker today is Tjon, who is the Deputy Director of the Center for the Study of European Contract Law in the University of Amsterdam. And she certainly has pride of place as the final speaker of the conference, and probably also has pride of topic in the intriguingness of the topic. So here comes my really strange Louisiana civil law connection. To common law eyes, of course, a contract for sexual services would be void as contrary to public policy. But there is one state in the Union which between 1898 and 1917 enforced as fully licit in the region of Storyville in the city of New Orleans contracts for sexual services. And the civil law of lease of labor was the title of the contract under which these were enforced. And so I'd be interested to know exactly under what rubric enforceability takes place in Europe and how warranties and protections figure into that. And Ms. Tjon will tell us about that now. Thank you.
Thank you. Well, so it's indeed my great honor to be the absolute last speaker of this conference, and I also realize that makes me the last person standing between you and the beach or something else. So I'll try to be brief and tell you about contracts for sexual services and consumer protection in Europe. Although the title is maybe a little bit of a misrepresentation, I will talk about this, but I will talk about it in the context of my larger research agenda, in which I'm particularly interested in the legal treatment of goods that are also subject to moral contestation. So goods that are debated about whether they should actually be subject to market rationality at all. And in my previous work, I, for instance, looked at consumption of goods that are made in sweatshops. This was actually the topic of my dissertation that I defended last year. And so currently I'm using the example of the consumption of sexual services in the European context to look at not so much the validity of those contracts, but at the question whether consumer protection is a possibility, and if so, how that would look like. So I do have a draft paper. It wasn't available. I didn't take hard copies, but if anybody's interested, please send me an email. I can send you the draft paper. Today in the presentation, I will only talk about one particular point, namely that it is possible, I believe, under in certain cases, that there will be consumer protection available for consumers of sexual services. And I will talk about how this is possible and why it's a problem if that is not immediately clear from the topic itself. Okay, so let's see. I've already moved that. So I'll start with saying just very briefly why this may be a problem. So the coming together of consumer protection law and sexual services on the European market. Now, in philosophical contributions to the debate on the moral limits of the market, most people agree, and probably we all agree in the room as well, that there are certain things that should not be sold on the market. Certain things, certain relationships, certain services should just not be subject to market rationality. We can think of selling babies is the obvious example, but also sexual services is in this realm of moral contestation. That debate about morality, of course, does not solve any legal question of how the law or policy and lawmakers should deal with those goods, services, and relationships. And so we see in Europe, for instance, a great divergence in how different member states of the European Union classify these domains. So which could actually fall within this realm of moral contestation that also becomes, for instance, legally problematic. We see it in the divergences of what's criminal. And the example that I will use, of course, is sexual services, which makes this particularly clear. Many member states in Europe either criminalize the buying of sexual services or even the selling of sexual services, but there are also member states, for instance, under Dutch law, which is not coincidentally where I'm from, of course, that I use this example, where voluntary prostitution is not illegal. And so the question is, okay, well, these relationships, if they're not illegal, if they're not criminal, how should private law, if at all, deal with such agreements for exchanging money for sex? So that's to say that there's legal divergence. In the moral debate about sexual services and the arguments that are given there about why or why not they should be beyond the moral limits of the market, we see a shared concern for the vulnerability of the sellers rather than the buyers. So in the moral debate, this particular topic often raises arguments about the risk that sellers of sex, prostitutes, sex workers, have in selling these things, because people say, well, certain things should only be sold under conditions of equality and substantive freedom, and sexual services are just an example of the fact that the people who sell that particular service are not equal or are not free. The arguments, of course, also made that the selling of sex on the market and receiving money for this is corruptive of the actual activity itself. And I will not refer to that any further. But that's just to show there are different arguments, of course, to be made about why it's immoral, but there's general agreement about the fact that there's an issue of vulnerability on the supply side with these services. And so the problem, of course, arises if these services are on the market and there's a possibility of consumer protection, this actually exacerbates rather than abates concerns we may have for the vulnerability of people on the supply side. Okay, so as you can see, I'm not very good at working with PowerPoint, but I've already said this, so I'll just move on to showing you how it's possible that sexual services on the internal market in Europe may receive, that there may be consumer protection available for such services. So I'm not so sure how familiar people are with the legal structure in Europe at the moment. Contract law questions used to be answered solely on the basis of national contract laws. So you would look indeed at the BGB of Germany or the Dutch Civil Code or the French Civil Code to figure out whether an agreement is valid, what rights and remedies people have, etc. But under development of Europeanization, many decades now, there have been considerable change. So instead of looking only at the national level, people will now have to look also at laws that come from a European origin, directives, regulations. We heard today people referencing the CESL, which is indeed still a proposal, and if adopted, it will regulate certain contracts on the internal market. And so there's this multi-level system of one contract or one transaction if engaging by parties cross-border within Europe, that you will have to look at, for instance, the BGB for particular questions, whereas you have to look at European directives, how they are transposed in national law, or even European regulation, how they apply to these particular relationships. So this multi-level system has been criticized for creating coherence problems, because these rules originate in different settings, and so lawmakers may pursue different objectives which may or may not conflict, or may not create issues that you might wonder, well, who's going to resolve this? Who has ultimate authority? And the answer is, we don't know. There's no resolution on many of those problems. So within this multi-level system, the question is, well, who decides where the moral limits of the market lie when you look at the contract law? So from a private law perspective, where are the moral limits of the market? Europe says nothing about this. Europe has no legal competence to regulate on this issue, so you will have to look at the different national civil codes. For instance, the BGB and the Dutch Civil Code, they each have standards of contractual morality, good morals, open norms that determine whether or not a contract on a certain substance can be regarded as void or null, and on that basis unenforceable. I will just refer to these as contracts that are invalid for immorality, for ease of explaining. But so it is clear that within the European Union there's many different answers to this question, whether a contract is immoral and on that basis invalid. And so I would say there's a plurality of moral limits of Europe's internal market, because Europe is not saying or is not putting forward the European standard on this issue. However, what Europe is doing, and very actively so, is providing directives and regulations in the area of consumer protection. And many of these rules are actually mandatory consumer protection rules. So contracting parties cannot say, well, we agree amongst each other that these rules do not apply to us. If a relationship falls within the scope of a directive or within the scope of a regulation, these rules will apply. For the CESL, that's a different subject, because the CESL is proposed as an optional instrument to which parties can opt into. So it's not mandatory as such, but as soon as you opt in, these are the rules that will regulate your relationship. So on the one hand, we see within Europe's internal market a plurality of moral limits of its market, and somewhat uniformity of consumer protection. Whether that's minimum or maximum depends on the type of regulation and directive that we're talking about. Okay, so now to illustrate this point on the basis of the topic that I'm talking about today, sexual services on the internal market, I already expressed earlier in the presentation, indeed there's one system, at least one system, I should say, namely the Netherlands, in which sexual services are not prima facie immoral and on that basis invalid. Contract, if you make an agreement to exchange sex for money, the courts say, well, if we look at common social opinion in Dutch society about what is acceptable behavior, these things are just tolerated, accepted, and so we cannot say that these contracts are immoral as such under the law, and therefore we cannot say on its basis that they're invalid. Some other member states, of course, criminalize the activity, or if they're not criminalized, indeed, under the common law of England, the courts would just say, well, this activity is, or this contract regards an immoral activity, and we're not going to help you pursue that through our contract law. So how does European consumer protection comes into play? Well, to use a particular example, you can imagine if you do research on this topic on the internet, you will find all types of things you didn't know existed, such as adult erotifications. When I saw it, I thought, of course, this exists, but I actually never thought about it. But there are many people who, or many websites at least, who offer such packages. So you can book both travel and accommodation, but you can also book your personal escort and indeed discuss the activities that that personal escort will provide you with while being on this vacation. So consumers on the European internal market can actually book these packages. If, in fact, for instance, such a consumer would be Dutch and Dutch law would be governing part of that contract, we would not say that that contract is immoral and for that reason invalid. What happens then? Are there other rules in Europe that then apply? Perhaps. We can see, for instance, that there is a travel package directive. This directive is currently under revision to be Europe is making a new directive on this topic, but this is just to illustrate what may be the result of the application of a European directive on this topic. Indeed, if you as a consumer or as a traveler book a travel package, well, all of a sudden now there's these mandatory consumer protection laws that apply. For instance, I wrote some in summary on the slide, but I will read to you some of the measures that are in this directive. The directive, broadly sketched, aims to offer mandatory protection to consumers of a package travel such that contract terms which derogate from the level of protection offered by the directive to the detriment of the consumer are not allowed. So in the contract, if you want to arrange something else that is not in the favor of the consumer, that will just be overruled. Now, examples of protective measures include the right of the consumer to transfer his booking, having first given the organizer or the retailer reasonable notice of his intentions before departure to a person who satisfies all the conditions applicable to the package. This may mean, of course, that all of a sudden somebody else will go on this holiday with this particular escort for these particular activities. One may say, well, that might be problematic if you consider the perspective of the person supplying these services. Another example is a duty of the organizer to notify the consumer as quickly as possible if she finds that before departure she is constrained to alter significantly any of these essential terms, such as the price, in order to enable him to take appropriate decisions and in particular to withdraw from the contract without penalty. The consumer thus has a right to withdraw from the contract under such circumstances. Now, there are many other examples, but these are just to illustrate the fact that the mandatory application of consumer law in these particular contracts, of course, do what they intend to do, namely to protect the consumer against the seller in this case. I would like to conclude by saying, again, what I've said before, this may be problematic. If we look at the moral debate about these particular services and this particular topic, we may want to have a concern for the supply side rather than the consumption side in this particular case. In the European context, this problem arises particularly because of the divergence of moral standards regarding the market, so they're national based and they diverge. But of course, these issues would also arise in a similar setting under just general contract law rules, because generally the directives in Europe nor are general contract law rules written with the aim to regulate sexual services. There seems to be something particular about these activities on the market that lawmakers have just not had in mind when they thought about these things. So that's to say that in the category of things that are contested, so things, relationships and services that we might consider to be beyond the moral limits of the market, this legal framework in Europe may raise some particular issues And I think I'm already done, which is before, well, I have 1 minute and I have one slide actually. And I would like to ask everybody to thank me, to help me thank Jennifer, Martin, and all the others. So that was a minute well spent, maybe.
Yes, it was. Thank you very much. So, a great panel. I want to thank all of you across the variety of topics. I think there's some commonality, and we'll turn that over to you folks out there to ask questions or make comments about the law of sales and consumer protection. Yes, sir.
A question for Larry and a question for Lynn. Larry, you mentioned there's no duty of good faith in English contract law. I'm wondering if there's some counterpart in English consumer protection law as to contracts. It sounded from later in the presentation like there might be, or at least that there might be something similar to warranty contracts, but I'm curious.
I don't need that.
Should I ask?
We have English scholars here that would probably at least correct me if I'm wrong, but the answer would be relatively no, it doesn't, but there are certain EU directives. The one I can think of is the Unfair Contracts Terms Act, which is really a consumer protection act that primarily says, I think, the choice of law clauses in consumer contracts are not enforceable. That is, the consumer always has the right to sue in their own jurisdiction. But the English have been very strong on not openly recognize the duty of good faith. Not to say they don't necessarily come out with what we would call a just or equitable outcome, but they wouldn't use that terminology.
In the back.
When you're comparing the relative merits of different international sales regimes, such as CISG or the English Act, it seems to me that you need to take into account the fact that international sales law is whatever the parties choose to make it be these days. I mean, every international sales agreement, I think, has a choice of law agreement. So the law pertaining to an international sale of goods might be Article 2, if that's what the parties choose. And this market in international law means that I assume that there's some statistics now on which of these regimes parties are choosing more frequently. If they happen to choose a regime that you find to be higher in transactions cost or less efficient, then what do we conclude from that?
You want me to say something? I can say something?
Yeah.
Oh, okay. You hit it in the sense of saying there's a market for these things. International sales law was generally the selection, superior bargaining power, of course, but that aside, the neutral laws were considered generally Swiss law, English law, and a few others, English law, I think, being more dominant one. The CISG, of course, is unique because it is actually, in a sense, hard law. It's adopted into the law of each and every country, and to date there's 80 now, and Brazil being number 79, really knocks off all the major trading countries other than India and the UK. We have 3,000 cases now, and probably another 3,000 unreported arbitral decisions applying to CISG, so there is a jurisprudence now. It's very uneven. Some of the things we thought would be very much in the jurisprudence, like the Battle of Forms and stuff, really hasn't come into play in like a meaningful part of that jurisprudence. There isn't a lot of cases there. Same thing with excuse. The excuse doctrine in the CISG, just a handful of cases. So I guess the answer to your question would be, yeah, it's up to the parties. The CISG, it just gives them another alternative when they're battling over a choice of law to say, why don't we do this? I think malpractice is committed every day in the United States when it comes to the CISG, because it is our federal sales law. And when you have a law that says no perfect tender rule, fundamental breach rule, which is incredibly incredibly pro-seller and has not first notice, that is, you get an extension of time, you know, the practitioner in this country who just simply takes the easy way out and says UCC should apply because we're familiar with it and we don't want to go with a foreign kind of law, is how can you opt out of something for your client without actually reading it and seeing how it would be beneficial? And we know all of private law is private law, so you can derogate from any of the provisions of the CISG. So I'm a proponent of the CISG only because it's disregarded so regularly by the profession without, I think, a real analysis.
One thing that I can just add to Larry's comments is that when you look at CISG versus Sale of Goods Act, CISG is more appropriate for manufactured goods, but simply it's not suitable for commodities. But Sale of Goods Act normally is applied to commodities because there are some certainties inherited in this legal regime, although as Larry said, there is no official commentary on the Sale of Goods Act to understand how it can actually apply into reality.
I think I want to recognize that we're in a Catholic place here, and therefore speak with the zeal of a convert. So I want to speak a little bit in favor of, in support of English law. And I'm a convert and not English, but I may therefore, on a more objective position, maybe take a position. And I think either I don't understand it or it has been misrepresented this afternoon, I thought, at one point, because both Reza and Professor DiMatteo have represented it in a way as being vague. And I think the one strength of English law is that it is not vague. That's why it doesn't recognize the notion of good faith, because that would introduce vagueness. It is very clear when you can terminate a contract. It has a very clear differentiation, and I'm probably confusing you now with the terminology, but in English law what we call a condition of a term, not in the sense of condition precedent, just in the sense of an essential term of a contract. Whenever you reach a condition, you can terminate the contract. You can get out of the contract. English law is bio-friendly because even a technical little breach of a condition, and in theory at least the parties are free in their contract to stipulate whatever has the quality of a condition, entitles the buyer to run away from the contract to say, give me my money back. The restitution point is, I don't know, that is then complete failure of consideration, because a condition is essential, and if a condition has been breached, there is a complete failure of consideration, and therefore there is no need to make restitution in all the cases. What you refer to the quality obligation, that is a condition that is defined in the statute. And if we want to compare the UCC and the Sale of Goods Act, we have to recognize that they serve completely different purposes. The UCC serves the purpose of bringing together 50
believe